Thank you all for joining us today. My name is Beth Winters. I'm a recovering attorney, and I'm also Solutions Marketing Manager at APARAVI, the Data Intelligence and Automation Platform. We help organizations find and unlock the value of data no matter where it lives. Our cloud-based platform finds, automates, governs, and consolidates distributed data. We ensure secure access for modern data demands of analytics, machine learning, and collaboration. APARAVI connects business and IT with legal and compliance to transform data into a competitive asset. I'm delighted to be joined by Paul Starrett and Stephen Wu. Paul, do you want to take a second to introduce yourself?
Sure. I am a founder and data scientist at Privacy Labs. You can read more about me on our website at privacylabs.ai. And I basically have an even mix of legal, technical, and data science background.
Thanks so much, Paul. Stephen?
Yeah, thank you for having me today, Beth. And I'm a shareholder at Silicon Valley Law Group in San Jose, California. I have been in the information technology and security and privacy business since the late 1990s. I served as co-chair of the American Bar Association Information Security Committee in the Science and Technology Law section. Later on, served as chair of the section. And day to day, I'm helping out with privacy policies, writing data security policies, and other documentation relating to privacy and security programs, helping out with compliance, transactions, liability, and investigations relating to privacy and security.
Thanks so much, Steve. So today we're going to be talking about automating data privacy compliance with a team approach. Before we get too much into it, I wanted to tell you a little bit more about APARAVI. APARAVI sits at the center of your data intelligence. As you know, a lot of different areas need access to your data and different departments, and APARAVI can help create a unified truth to your data and augment the data ecosystem with our data intelligence platform. Today, our panel is going to be focused on a case study. So we are going to be talking about a mid-sized corporation in the U.S., customers in the U.S., Europe, and South America. This company is subject to a variety of different data privacy laws, including GDPR, CCPA. The company offers home automation solutions, basically smart home solutions, IoT enabled, like alarm systems, thermostats, garage door openers, and security cameras, as well as other IoT B2C devices. The company has a small in-house legal staff for all practice areas that are relevant to the corporation, and there is not currently a data privacy officer or CISO assigned. Now, recently they've received several DSAR requests, that's data subject access requests, in the past, and they all handled those on an ad hoc basis. But with the passage of CCPA, GDPR, and LGPD, they're concerned about an influx of requests. They don't have a technology solution or workflows in place for DSAR requests, and they first wrote a privacy policy when they first started business in 2001, but they've not updated it since. They recently had a cybersecurity breach, which was relatively small in scope, but they want to update their technology and policies to proactively mitigate the impacts of any future security incidents. They had security teams that helped design the product and initially assumed the product was secure, but now they understand that they need additional security measures in place. So we're going to be talking around this case study. But first we're going to get into why a team approach to this type of situation would make sense. So Steve, do you want to kick it off?
Sure. As an attorney, I'm helping companies write privacy policies. So in the case of our case study here, I'd probably be asked as outside counsel to help update the privacy policy that hasn't been updated in a long, long time. But when I think about my job in writing privacy policies, I'm often getting into the questions like, what kind of data do you have? And how does it come into your organization? How do you use it? Do you have any third parties that you share it with? And where does it go after you're done using it? How long do you keep it? And things like that. And I have a range of clients and size, but I'm not the one to be looking at individual servers and trying to track down where data might be or what kinds of data there might be in the organization. It's just not either cost effective or within my capability to go over to the place of business, especially in COVID, to go over to their place of business and try to track down all these different kinds of data. I need to rely on my clients and other professionals to be able to do that part. I just don't have the ability, and it's not really cost effective at the same time. So that's why it makes sense as a lawyer that there be other professionals and solution providers to help an organization. And there's a certain size of organization, maybe below that size, that it's just that the company's too small to afford any other type of help other than my help. But once you get past that size for any mid-size or larger businesses, then you really need to have a team approach in order to be efficient in the way that you're tracking things down and figuring out what the data flows are.
Well, it's also difficult for you as an attorney to make decisions about the privacy policy without knowing what types of data they're collecting. And as you mentioned, I think attorneys are reluctant to propose technology solutions for their clients because that's really outside the scope, and they don't want to show that they're somehow associated with a particular technology. Is that right?
Yeah, I mean, we try to have an independence. So our job is to provide legal advice to our clients. We're not in the business of recommending particular solutions, but to say you really would benefit from having a solution, and here's maybe I might provide them with some possibilities or point them in the direction of where to find them. But certainly there's that independence. But I was going to say also on the security side, when you're talking about this data breach, figuring out what happened in connection with this breach, thinking about proactive security measures that a company would take to prevent breaches in the future. I'm not the one to look at firewall settings. I'm not the one to check to make sure that background checks are always done. I rely on my clients' organizations and their assistants to provide that kind of information for me. And then to go to your point, it really is a fundamental thing to my advice to a client to know what the facts are. And I'm depending on other people to investigate and determine those facts, like what kind of data do you have, or what are your firewall settings, and have you updated all your patches? So all of these things, I rely on other people. I can give the advice based on, you need to do this. I can give the advice based on, hey, based on what you're telling me, what the firewall patches are, or the patch levels, or your patch program, or what the firewall settings are. I can give you advice based on those facts, but I'm not the one to be finding those facts.
Right, and it's pretty uncommon for someone to be both an attorney and a technologist like Paul. So Paul, maybe you can talk a little bit about your approach, why you need a team.
Right, and I think just to kind of tee this up a little bit more, in electronic discovery, for example, which I'm sure there are many on this call have familiarity with, when you are talking about limits of professional competence, for example, the California State Bar requires that you associate in someone who can help you become competent if you're not, which is common. And I think that's kind of where we're going with this, is that you want to make sure, if you're counsel, that you do that and that you find somebody who is adept at addressing the technology challenges with an engagement or with a client. And so that's kind of where I step in. I do have a license to practice law. I have worked as a chief risk officer. In fact, Steve Wu is my outside counsel, and I was in-house at one point. We've known each other for quite some time, actually. We met at the Information Security Committee back in the late 90s. Anyway, I digress. The point is that what I can help with is making that translation between the law what Steve does for a living, and that's where he's the expert, and the technologists or the data scientists or the solution architects, whatever, to make sure that those kind of come together to herd the cats.
Yeah, and let me just jump in here and just add a couple other things. One is that when you have an organization of a certain size or above, then the risk is that you're going to have a lot of manual processes going on, and you're going to run around like chickens with your heads cut off if you have starting to get a larger volume of data subject access requests. And what we're talking about is, hey, please delete me data, or show me the data that you have on me so that I could review it and update it. Those are examples of data subject access requests. And you're going to, if you have manual processes, then you're going to have inefficiencies because you won't have set procedures. You're going to be running around trying to do everything on the fly, figure out how to do it, and then do it. I mean, it's just a very inefficient process. The natural thing then is to say, okay, can we have an automation solution so that we can make this a process that's repeatable, that it's something that everybody knows about, we can train people on it, it will increase the speed of it, increase the efficiency of it, and that's all great. But there's another piece which is missing, which is, it's from my perspective, if my client buys a solution but then doesn't know how to use it or has no training or it's not integrated with their systems, then you're missing something. And so Paul's company comes in to be able to provide the glue between the solution and then the attorney trying to say, give me the facts. You need to have something in between so that you're working together. And that's why all three of these solution provider, consultant, and attorney work together as a team efficiently and effectively.
Yeah, and if I could just tail off of that, is that a lot of people think about open source tools. These are free. Go to apache.org. A lot of people go there. The problem with that is that if you don't understand it, there's no 800 number. And there's no formal training necessarily. So a tool like APARAVI's, again, the commercial, that is really a net gain, I think. So I think people need to think about that as an issue.
Right. I mean, and from our point of view, obviously, I'm not, while I am a solutions marketing manager at APARAVI and I am an attorney, I'm not practicing law in the sense that I'm in a position to give legal advice to our clients. I want to be that bridge and help them connect the data privacy concerns and compliance issues with their unstructured data. So having somebody like Paul is great, so we can connect with our open API to the other systems, make sure that the data intelligence and data management are being addressed from the IT side as well as the business side, and that compliance and legal are in a place to also use that data, and those different departments use different systems to draw from the data.
Yes. It's also important on the flip side of this discussion to say, could I, as a company, just skip the attorney piece and then just use consultants to set up my privacy program? The problem with that is that when you're asking for a compliance decision as to here's the law and here's how it applies to your organization, that's the practice of law. And technically, if you just go to a consultant or solution provider or both and say, please give me legal advice, and please write my privacy policy and tell me that I'm compliant with the law, all of that adds up to the practice of law that is unauthorized under the laws of the various states. So there is the need for an attorney to provide some oversight to this whole process to make sure there is compliance with law, and that's the licensed person to be able to take the law and apply it to an individual organization with judgment.
Right.
Yeah.
And with our technology, we have 140 plus classification policies, which are basically different laws that you might need to comply with, but we can't tell you which laws you need to comply with. That's something that you need to know from your counsel.
Yeah, and if I could just kind of continue that thought, the ability to do that in unstructured data, by the way, I think is a really an important capability, because that's where the biggest challenge is, and that's where 80% of the data is. So I think that's a good thing. And if I could just touch real briefly, because my role in this is to make sure that we try to bring together all these different components. So in the bottom right of the slide right now, we have efficiency and budgetary constraints. One thing that this particular, in our case study, this entity is not likely to be able to hire in-house. They could. They're likely to reach out to others on an ad hoc basis or piecemeal basis to get these things done. It doesn't mean there won't be an ongoing relationship, but it's going to be a third-party relationship. So efficiency and budgetary constraints really help make the case for a consultancy to come in and help with things rather than having to take on full-time staff, which may not be necessary. And it's kind of a nuance there with what Steve said with unauthorized practice of law, UPL, they call it sometimes. That's technically a misdemeanor, it's a crime. I'm not sure it's high on any DA or Attorney General's list of things to go after, but there's a nuance in insurance coverage that if you hire a third party and that third party is supposed to have insurance, then you want to make sure that their coverage is appropriate because, for example, in the policies that I have had or either have now or have had, I'm required to have insurance for a specific type of activity. So, for example, I have a private investigator license and we have to do investigations. The state of California requires that. There is an insurance products or policies specifically offered to private investigators based on the type of risk that they have, and that's what that's built for. As well with lawyers, there is malpractice insurance, and that is specifically built around the risk involved with practicing law. The problem comes in with if your third-party consultant is practicing law without a license or is doing something that they shouldn't in that way, their insurance might not cover them. If that's the case, and you have a contract with them that requires them to have insurance, you can see where this becomes kind of a concern. So I would encourage people to make sure that that is covered properly in your contracts. And so in any way, bringing it down to earth in this case study.
And Paul, you can assume that insurance companies are going to be fairly aggressive about not wanting to cover any edge cases.
Right, because for example, my policy that I have for E&O, and I'm going to get carried away here, but it actually says this: if the activity that you're engaged in requires a license, they carve that out as an exception to what they'll offer. So I think this is something that I found that I think needs to be brought to the fore, because it's something that we like to pay attention to. We have insurance, by the way, so no one knows. I'm very well aware of this issue. I don't generally practice law. I have the background. I let Steve do that. He's the expert, and I let APARAVI handle the way in which the tool works. So, in any event, I'm done with regard to this slide. I think that I've made my.
No, thank you, Paul. Thanks for going into detail about that. So, along the lines of efficiency and budgetary constraints, we're talking about automation here. So, with APARAVI, we're able to automate some of your data governance policies so that you can efficiently remediate data, that you can go through your data and be able to defensively dispose of data when you need to, and move the data automatically in accordance with your data governance policies. And so the benefits of automation include reducing human error, just the fact that it's too much data to process manually. Nobody could read through it all. So you get this completeness. You're able to take the data and put it in a way that you can visualize and analyze your data. And it also helps make sure, to address data quality concerns. Paul, maybe you can speak a little bit more to data quality and diversity of data.
Yes, and I would actually probably loop the integration with other applications. And this is kind of a horizontally broad topic, so I'm going to try and approach this in the best way that I can. I think that with data quality, the ability to make sure, for example, a lot of privacy regulations require data quality, which includes as a primary requirement that if you have two pieces of data that are really belong to the same person or entity or issue, maybe there's an issue, that you can find that and bring them together, make sure that all pieces of data that apply to an individual, for example, are found and accommodated together, rather than not knowing that Paul Starrett is different than Starrett Paul. That's an obvious example, but having tools will help make sure that that data is of high quality.
Maybe more
so
like
when you are
maybe more like Steve Wu and Stephen Wu, right?
Right, or WOO. I mean, if you are in an, where it's phonetic, where you have sound or something, there's any number of ways in which that can come about. But so that's one aspect of data quality. Then there's diversity of data, and I think that being able to identify, generally you've got structured data, unstructured data, and you have, when you get into machine learning, and I don't want to go in that path right now, but you have numeric and categorical data, and they're all treated differently. And the way in which you bring that together is very important, because again, it's a matter of herding the cats. Then with regard to the integration with other applications, I think this is a very important factor in compliance, which is to say that a tool like APARAVI will certainly be a centerpiece where everything can be brought into the same location. It may be, though, that an enterprise has existing tools that are built specifically for a certain type of threat, like a firewall we were talking about, or intrusion detection, where they are built specifically for a certain type of data analysis. They are generating intelligence that might need to be shared with a tool like APARAVI and vice versa. And so I think integration becomes really key. And so there's a thing like a data catalog. If you were to Google data catalog, all kinds of things will come up. That's a place where these tools can bring their intelligence into one place and can be monitored and accessed there. So that's really becoming kind of a data synergy, if you will, and important in areas of compliance where you have to look at everything cross-channel, as they say. And the last thing I'll mention
also goes back to specialization as well, that, you obviously, our technology specializes in unstructured data, but you'll need other tools, right, that can deal with structured data and your other applications. And that's where the consultant can help. Mm-hmm.
That's right. And I think there's another important distinction here too, is that you really, what we do is we structure unstructured data. So once it's structured, it can then be matched to what's already structured. So I think that's an important distinction. So for example, in free-form text, you're in an email and you need to find personal data or whatever, then your tool would find it.
Right.
If you found my name in an email, it would then join it.
Right.
Yeah. In
our tool
a
searches
let's say,
the metadata and the content. Right.
Right. And then matches that with, let's say, a spreadsheet in HR or a financial statement or financial, So, and if you think I have time, I'd like to just touch on one other topic that has to do with artificial intelligence. Do we think we have time for that?
Yeah, go for it. Yep.
Yeah. And the reason I mention it is because we're seeing this more and more now, that as data becomes more vexing, it becomes more diverse, and it becomes more challenging, people are looking to artificial intelligence as one way of wrangling the data. And there's an issue with explainability. Again, I wouldn't mention this if I didn't think it was important generally, but it's becoming more important. That generally a machine learning model is, the more accurate it is, the less explainable it is. And the more simple it is, the simpler it is, the more explainable it is. So for example, you may have heard of deep learning, and I'm going to bring this back to our topic here. Deep learning is highly accurate and the ROI is very good, but they're not explainable. And I'm going to leave you with a quick example. There was a project, and I haven't really found exactly where this is, but I know it's true, and it makes sense from the standpoint of just hypothetically. This research group had thousands of pictures of dogs and thousands of pictures of wolves. And some of you in the audience may have heard of this before. But it was very good at finding the wolves. It was like 90% accurate. Turns out it was picking out the snow in the background in the pictures of the wolves, which really is not helpful. It was accurate, but it was based on the wrong information. And with deep learning, it doesn't care what it finds in the data. It found snow with the wolves in the pictures, and that's what it picked, and it just used it. This is the problem with explainability. These deep learning and more complex machine learning models, if you don't know how they're working, that's a problem, both for compliance reasons and for commercial purposes. So the reason I mention that is because this is a very big topic right now. Oftentimes it's better to start with a tool that's more of a search, more of a regular expression, more of a workflow based like what APARAVI has. I know that natural language processing and other things aside, that's where oftentimes it makes more sense to start with something that's as simple and straightforward and understandable as what APARAVI uses as its base tool. So that's why I'm mentioning that. So it's oftentimes better to think there first before going off into machine learning.
Yeah, I look at the future possibility of liability for not having transparent systems. And under the GDPR, for example, transparency is an important aspect of processing personal data. And if there's a lack of transparency because you don't know how it works yourself, then you have a potential liability problem.
Yeah, and there's two buckets there. I'll make this real quick. There's fairness and bias, which has to do with discrimination, and then you have automated decision-making, which GDPR touches on, that if a person is impacted in some legal way, or I don't know what the wording is exactly, they're entitled to an explanation for how that tool made its decision. But there's also an entity buys a software product, and it's supposed to do what they bought it for. So in these audit frameworks that we're looking at closely, we do this, we audit AI. Is it going to crash your system? Is it going to cause whatever you bought it for to not actually do what it's supposed to? So it's a risk to the actual enterprise, infrastructure. And then you also have the issue of explainability with regard to the regulation. So it's a twofold thing. And so it's important. So that's why straightforwardness is so key. And I think APARAVI really has that nailed. You've got complexity, you've got breadth, you've got lots of capability, right, but everyone understands it when they look at it. So.
Right. And under the GDPR and under CCPA, you have a short window to respond to these DSAR requests, 30 to 45 days. That doesn't mean you necessarily have to come back with the answer in that time, but you have to tell them, yes, I'm working on it, something like that. But we help you really find the information quickly, seamlessly, and really help you respond to those information requests in a timely manner. So it's not burdensome. You don't have to necessarily ask IT for help. You can do it on your own on the compliance side or on the legal side.
And I would also echo that in breach, sorry, real quick, data breach,
yeah,
you have even less time. And so and then you can just
right,
fill in the blanks with what you just said.
You have
yeah.
Right,
so
72 hours
company,
or something to report a breach.
So our small company, our small company then would be in a good place for that. Sorry, Steve, go ahead.
Yeah, I was just going to say that there are plaintiffs' lawyers who are looking for violations. Some people might call them technicalities, but looking for violations. So if you're missing your deadlines, then you have potential claims against you. If you're not meeting the deadlines because you have too manual of a process and you're running around with a chaotic situation of trying to invent on the fly how to find the information you need to respond to it, these are, and then respond to it.
Right, and currently with CCPA and the new CPRA, it's a little bit up in the air what's going to happen with class action lawsuits as they are moving their way through the system. But you definitely want to be aware of those issues when you do have a cybersecurity breach, when you do identify the breach, reporting it within that 72 hours, and then what we can do also is help inform you who was actually impacted by that breach, with the information of which of your customers was in that file location. So you can really do your due diligence there and not necessarily have to expose yourself to unnecessary liability by informing all of your customers that their data might have been breached.
Yeah, just to follow up on your point about plaintiffs' lawyers, I mean, there are also potentially government lawyers that might go after you for these kinds of violations, or they might be called unfair and deceptive trade practices separately apart from CCPA. But there is a section in CCPA that seems to suggest that it might not be used as a basis for a claim by plaintiffs' lawyers, but a lot of or most of the recent suits filed under CCPA have tried to allege violations of CCPA,
Right.
like that section.
Right.
Yeah, it'll be interesting to see how the courts come out on that. But now we've moved on to the next slide to talk about how to set up a privacy program or how to set up a data protection program. And to let people know, we have a handout that describes a lot of this in detail, and it's on page 12 of the PDF handout. So a lot of the detail I'm going to be talking about is from that document that should be distributed to you. But we created a 7-step process. It's called a 6-step process in my paper, but we've kind of expanded it a little bit. But there's a 7-step process to create a data protection program. The first and most important piece of it is to decide what is the role of data protection in your overall business strategy. And why do I say that? Because if you're a company that says we gain a competitive advantage because we're known in the marketplace of taking special care of our customers' personal data, then you're going to realize how important that is, and it's going to flow down from the very top of the organization to everybody within the organization to be able to follow through and maintain the reputation of that company. So understanding what your business is all about, are you highly regulated as an industry, all of these things will factor into how important is data protection so that you can decide how to resource your data protection program. And you will need leadership from the very top of the organization to say, we're making a commitment to this. This is not just something we're checking the box with. This is something that we will make a business commitment, and we will commit the time, effort, resources, money, whatever it takes to make sure that we follow through with the strategy. And then you're focusing on trying to craft your data protection strategy with the features, capabilities, and vulnerabilities associated with your particular environment. So that's the very beginning. That's the first step. The second step is to understand your current data protection posture. And what I mean by that is to say, what kind of personal data do you have? How does it flow through your organization, as I was mentioning earlier? What kinds of information assets do you have in terms of networks, devices, data? Understand also the applicable laws that you need to deal with when you're dealing with personal information. So you should do an analysis of the laws that apply to your particular business. And then you need to, from a security perspective, you need to conduct a risk assessment. You don't know what types of risks you're facing or how to deal with them until you go through a thorough risk assessment process. And what we're talking about there,
you also need, right, you need to know what data you have in order to do that risk assessment.
Yeah, as I mentioned at the beginning of the talk, what kind of data do you have? How does it flow through your organization? Where do you get it from? Do people give it to you, or do you collect it yourself? How does it come into your organization? How do you use it? What are the different uses? What third parties do you share it with? And then where does it go? Is it exported to other parties, other service providers? Is it archived? Is it deleted? So understanding the information life cycle throughout your organization is really important. And from a security perspective,
that will also inform later on your data privacy policy.
Right.
Because you need to have transparency of usage.
Yeah. So as part of the step, you're going to be coming up with privacy and security policies, procedures, and controls to put into place to manage the risks that you've identified and to be reasonable and appropriate in compliance with the law to create privacy policies, security policies, and other types of documentation to address any gaps and risks that your company is facing. The third step is to say, okay, now that we have the policies and procedures in place, we understand our data protection policy. The third step was to develop a set of controls and practices to address your risks. But the fourth step is to actually implement the controls and close the gaps that you identified. So you have, in step 3, a set of controls on paper, policies and procedures on paper, Now you actually have to put this into the real world. So step 4 is all about putting that in place in the real world. And what does that mean? That you have agreements that call out these policies and procedures. You're monitoring and providing day-to-day oversight over the implementation of the program. You're going to train your personnel to make sure they understand their data protection functions. Also, as part of the HR process, you should make sure that people are following the policies and procedures that you've laid out, and if they're not, then they're held accountable for it in their employment reviews.
So,
and then,
Steve,
yeah,
maybe you can put this in context of the case study, right? What were some of those gaps? What are some of those practices that they'll need to implement and their current data protection posture?
Well, so far in our case study, it seems like we have an organization that's out of step with the latest. It doesn't have an up-to-date security policy. It doesn't have an up-to-date privacy policy. So it has to go through these steps 1 through 4 in order to make sure that it's updating its old privacy policy, and then to make sure that it has a robust set of security policies after having redone its risk assessment, if it hasn't done one in the first place, and an analysis of applicable law. Then it has to implement what it.
Yeah, definitely. And in terms of the cybersecurity breach, they had not, when they were designing the products, they initially had a security expert that helped with that, but they haven't had anybody look at cybersecurity since then.
Right. So first of all, just because the product was tested at version 1 doesn't mean that when versions 2 through X come out that there haven't been new vulnerabilities that are introduced. Plus, the threat environment is constantly changing, so you're always going to have new threats that arise. And it's apparent that this case study company did not engage in an enterprise security review, so that all of the systems that are supporting the IoT devices are evaluated as well. Just because you look at the device, and let's say the device is totally secure, there's an online account that's associated with this, the way to manage the device, the way to store the data, to view the data as a customer of this company. All of those systems need to be evaluated as well.
And under, with an IoT device, what type of data are they collecting? What type of personally identifiable information could fall under, the data privacy laws? It could be, right, like you said, email address, but there's a lot of information it might be pinging back, right?
You have videos, so you're talking about potentially personal information in the form of videos being taken, audio potential for some of these devices. You could have health-related devices with IoT that are collecting weight or heartbeat or number of steps you've taken. All kinds of personal information could be associated with those devices.
Does GPS also qualify?
Yeah.
I'm sorry, what?
GPS location?
Oh, yes. So geolocation is another important piece of that as well. Geolocation is particularly sensitive. It's actually called out as a particular category of personal data in the California Consumer Privacy Act.
Right, and IP address. So there's a lot of different types of information that could be made vulnerable, especially with IoT devices.
So just going back to our 7 steps, we talked about sustaining and managing a program through training, day-to-day oversight, holding people accountable. The 6th piece is having formal programs of assessment and auditing. Paul mentioned auditing earlier, but audit and assessment is an important piece to know. Are you actually implementing the program that you said you would? And you could have external audits like a SOC 2 report done by an accounting firm, or have a certification body look at your qualifications to meet the criteria in ISO 27001 to have a security certification, and SOC 2 reports can talk about privacy as well. So they're all there's going to be ISO work in the privacy area as well. So you should have a formal program of auditing assessment. You could have some internal auditing, internal assessments, as well as external by an independent third party. And when customers of the products want to know that a company is secure, they might say, "Show me your audit," and we won't buy it unless you have the audit. And then the final piece.
You mentioned. You mentioned, having support, from upper management, right, in sustaining your data protection program and managing it. I mean, this organization in our case study, they don't have a data privacy officer, so they'd have to assign somebody, and that person could help be responsible, probably at a C-suite level. What are your thoughts on that?
Yeah, I mean, one of the important administrative controls that any organization should have is to have a single point of contact, a single person who's responsible. That way, if it's everybody's responsibility, it's nobody's responsibility. You need to have a single person who says, okay, I am responsible, and I'll take that responsibility, so that if something goes wrong, you point to that person and say, okay, you need to fix this. You need to fix this. So I think it's really important to have a privacy officer or a security officer or both in a large enough organization so that you have that type of accountability. And just to close the loop on the seventh step, it's reevaluating your data protection program and making changes, so you can look at audit results, and then based on that audit result say, oh, we need to make changes in these controls, these security controls, or we need to, some new laws have come up, we need to reevaluate our program. So it kind of circles back and goes back to the beginning, so that you could say, okay, we now need to redo our privacy policy and our security policy based on changes that have taken place. So anyway, that's the big picture of those 7-step process for your data protection program.
Right. And so now we're going to talk a little. Oh, sorry. Go ahead, Paul.
Yeah, if I could just touch on a few of these real quick.
Absolutely.
Yeah. So I did want to emphasize the number 6 is really key, because I think you have to look at it holistically, all these different things, the privacy, the security, all of those are wrapped into the same thing. They're really basically saying the same thing. It's like the GDPR is the General Data Protection Regulation, not privacy regulation. So those are so tightly bound. And I think you really have to work with a person internally or externally, if you're hiring outside, that understands how holistic that is. And I do want to leave you with a couple quick thoughts on recent solutions and challenges. There's a thing called, in number 2, you see the term posture, protection posture. There's an area of cybersecurity called Cloud Security Posture Management, CSPM. Cloud Security Posture Management is becoming big. And that could apply to a smaller organization. They can be cost effective and very helpful as people move to the cloud, because the cloud is oftentimes cheaper, and it is a place where people can bring various amounts of data together to be analyzed in one place, which is key in compliance. The last thing I'll leave you with is an area called serverless computing, and this is changing the threat landscape at a high level in cybersecurity and information security, where the use of servers is actually not being done anymore. They're being offered as services by providers, where a lot of the things that you normally think about with hardening an operating system or worrying about firewalls and so forth, those are not nearly as vexing. They're moving to the serverless. And so that removes many things, but it adds new additional issues with what they call web application firewalls and with application security. So we don't have time to discuss that now, but I think those are trending areas where, and this is in the last year or two. I mean, so application security, where they're looking at the security of the software that's being used to write applications. So those are 2 areas I think that we're going to see a strong growth, hockey stick type of growth coming up. So I just want to make sure I put that out there.
Thank you so much. Yeah. So we're going to go into the 3rd step in a little bit more detail here, and that's the controls and practices. And specifically, we're going to talk about cybersecurity incident response. So, Steve, I'm going to hand it back to you.
Yeah, so we have in our case study a company that's experienced a breach, and so it should make sure that it has robust controls and practices regarding cybersecurity incidents. And the very first and most important thing is there should be an incident response plan. Remember, I talked about a security policy, and usually that's a high-level document. Sometimes it has all the components. For a smaller organization, it may have incident response components too, but often, or most frequently, when you're talking about large organizations, there's a separate document that's the incident response plan. If you don't have an incident response plan, then when an incident occurs, you're going to be, again, running around in a chaotic situation trying to figure out how do I respond to this incident. You need to plan in advance for any cybersecurity incidents. And then as part of that planning process, you need to know who are the people who are going to be helping you to carry out this plan. You don't want to figure out, oh, okay, we've got an incident. Who should we get to carry out this plan? That should be figured out in advance. So allocate your team, who's responsible for what.
And you don't want to be in a situation, like you said, where people are pointing fingers. You know, I thought IT was taking care of it, or something like that.
Yeah. And as part of the preparation too, letting workers know in advance if you see something, if you think that there's a breach that's taken place, if you see a vulnerability in our system, here's how to report it. Fill out this form, send it to this person. I mean, having a set of procedures so that people know, almost like when you're driving a car and somebody veers out in front of you, you don't think, oh, what do I need to do now? I mean, you kind of react as just an instinctual thing. And that's the level of response that you need when you have a cybersecurity event. If it's something it's so ingrained in them due to their robust training that they know exactly what to do, and they do it right away, and they have no questions on how to do it, then that's the most effective way of responding to an incident. And as part of that, there should be some more detailed procedures about how to report incidents up to upper management so that management can decide what to do. And then once it's in management's hands, the report has been made, then management needs to decide which resources are we going to bring in for this investigation. If it's something small and minor, like there was an unexplained login at 2 a.m., and maybe that's something that's it's not really clear that there's anything going on there. Maybe it was just somebody who was on travel and logging in remotely or something. You know, there could be a lot of innocent explanations for a lot of things. Then that's not something you may want to spend money on for external resources. But if you know that there's a serious breach, there's an important aspect of bringing in external resources for an investigation. Part of that has to do with the legal issue of the attorney-client privilege. And what we're talking about is communications between an attorney and a client that are held in confidence for the purpose of giving or receiving legal advice are confidential. And if, let's say, there was a legal proceeding later on and the opposing attorney asks, what did you tell your lawyer about this particular incident? That conversation was privileged and can be objected to based on the attorney-client privilege. When you have an outside attorney doing an investigation of your breach, and there's something that goes bad, or you tell your attorney, oh, our security posture was missing this key component, then nobody can ask about that conversation. No opposing attorney can ask about that conversation in a court proceeding or deposition. So you want to have an external resource. If you have internal counsel do it, there's going to be potentially a fight over whether that attorney was acting in a business capacity or in a legal capacity. So it kind of muddies the water. That's why it's best to have an external attorney. And then you'd say, well, we have internal technical people to do the investigation. And there too, you have a benefit of having an external forensic investigator do the investigation. Because if the forensic investigator is acting as an arm of the attorney, and the forensic investigator is having that conversation with the client, and the client says, oh, we had this vulnerability and we didn't take care of it, and we should have taken care of it, but we didn't. That conversation can be protected by the attorney-client privilege, even though the attorney's not in the room. Why? Because the forensic investigator is an arm of the attorney in having that conversation. And if you structure the agreement between the attorney, the forensic investigator, and the client correctly, and have some appropriate language to make it clear that the investigator is acting as an arm of the attorney, then that conversation can be protected by the attorney-client privilege. And then, of course, the investigation goes on, the facts are found out, and then there may be some reporting requirements externally to the organization. So some breach notification laws require telling the individual or telling the attorney general. And of course, if it's in the news, then you want to have some PR people to help you craft a message to say, we're aware of this, we're on top of this, we take security seriously, this has happened, we're very sorry, and here's the steps we're taking to make sure that we take care of the problem. Those are the kinds of messages that you want to be saying from an external PR perspective. And from a legal perspective, there may be anticipation that your customers who are affected by the breach might file claims against you. And equally, there might be intermediaries that actually cause the breach. You may not be totally at fault. It may be another party, a service provider, for example, that was actually the one at fault. And so there might be claims against that service provider. But equally, you have to potentially have claims that are going to be filed against you that you have to analyze. And then finally, now that you've had all this incident response procedure, it's all documented, you know what to do, you've got all your team set up and everything, you have to make sure that you practice this from time to time to make sure that it's effective. Having an exercise to go through the process of a hypothetical incident response is the way to practice. It's like you practice a violin in order to get better. You can practice your incident response to make sure that your systems are working properly and you're doing it well.
Yeah, this is Paul. Can I'd just like to add,
Yeah, go
I
ahead.
think from a technical standpoint, the best way to herd the cats, that keeps coming up, but it does for a reason, is there are managed service providers that can provide monitoring tools that will basically ingest all of the logs from your servers, whether it's a firewall or intrusion detection or Salesforce or whatever. Those are all brought together into one central location, and then tools like Splunk or Sumo Logic, you don't have to break these down or anything. These are just, what they do is those tools analyze this collection of logs, and that can be used not only to alert you to issues that come up that are apparent across these applications, but also facilitates what's called root cause analysis in the investigation. So I think this company we're talking about, the case study, I think there are cost-effective solutions along these lines of a managed service provider who does have this sort of log ingestion and analysis capability. Very cost-effective and very helpful. And then the last thing I would do is
brings us
just real quick,
back to like the audit.
If you do have audit, absolutely. But also, again, if you have a third party and they're not covered by the insurance for reasons we mentioned, they come off the list of deep pockets. And again, that's a whole other thing, but that's why it's important to really know who your third party, who's providing you services, what do you have in your contracts with them, and what kind of insurance do they have, and because that becomes important if you are sued and you have to join someone else as a co-defendant. And Steve, maybe you can talk more to that, but I just think that the insurance always plays a big role in who the plaintiff's lawyers choose to sue.
Yeah, I mean, notifying if you have cyber risk insurance, notifying your insurance carrier is an important piece of the response as well. Yeah, we've actually had a question. Paul, we had a question that came up about, do you have some resources to recommend regarding cloud security, posture management, and serverless computing?
Yes. If you Google that, some things will come up. And I apologize. Maybe it's my lack of caffeine. There is a company that most of the major information security companies will have something like this. There's also a thing called cloud workload protection, which kind of gets built around the edge. But you know what I can do is I can get back to you. There's a company that I do have a particular affinity for, one that I've actually used internally, and they're wonderful. It gives you everything. And for some reason, my brain, I apologize. I'm drawing a blank. But if you do cloud security posture management, the Google search, you should get back all the major players on that topic.
Right. And just to, bring it back to our case study once more. This is a medium-sized company, right? They don't have a lot of resources. Paul, how can you make sure that this is automated? And I know you were talking about part of that. What are some other ways to automate this incident response?
Well, I think that's a good question. Let me get back to that last question. All of the major cloud providers have a tool that will analyze cloud security posture management. So if you go to AWS or Microsoft Azure or GCP, they will have tools built in, but they're a third party, and I should know this. But anyway, to your question, I think the best way to automate it, it really depends on the problem that you're trying to solve. Generally, you're automating simple tasks so that you don't have to worry about the automation going off the rails somehow. But if you wanted to, say, for example, communicate between two different applications, you can set up all of these tools have the ability to talk to each other using connectors. And in that connection, you can decide, okay, what information am I going to share with you, and what do I expect back in the way of proof that it was sent for auditing purposes? Who do I have to notify? Do I have to send an email to somebody? Do I have to log something in a log? So you can find API programmers, or there's tools like Tray.io, Tray.io, where this can be done where there's no coding. Or MuleSoft is another one. They're larger. And then Zapier, Z-A-P-I-E-R. I believe that's right. I like Tray personally. Yeah. But that's when or you can hire a professional API programmer. Typically, that's probably what we would do in Python or something like that.
Right. So as a consultant, you kind of act as an integrator for all of these different specialists to come together to help the client automate these different processes.
That's exactly right.
Because
we walk them. Yeah, we walk them through it if it's necessary. We don't push anything on anyone, least of all AI.
Sure.
But yes, that's exactly. It's what makes the most sense, what's simple, what do we know is going to work, what's cost effective, which is always a big question. But yes, that's what we do. Absolutely.
Great. And we have about a minute left. So I just wanted to thank you both for a great conversation, Paul and Stephen. And I wanted to leave you all with a little bit more about APARAVI. As you can see, our dashboard helps you visualize your data, help you reduce risk and costs, and increase automation. We have 140 plus predefined classification policies, which are really simple to apply to your data. It's a click on, click off button. So you can apply policies like GDPR, CCPA, PCI DSS, HIPAA, whatever applies to your organization. And I'd invite all of you to download a free trial of our product on the Microsoft Azure Marketplace, where you can install it yourself, or you can give us a call or go to our website to schedule a dark data assessment or schedule a remote install.